Francis-Xavier Sosu is a member of parliament representing the people of Madina. He's a human rights activist and a lawyer. Counsel, you're welcome to Eyewitness News. You've heard the argument, you followed the debate. Should the lady be called or not? And why? Can you please explain to us your position?
Thank you very much, Umaru and Sanda, and a very good evening to your cherished listeners, and a good evening to my learned senior on the other side. I think that we must, as a people, agree that we treat each other fairly, reasonably, and also observe all the rules of, I would say, administrative justice when it comes to matters like this. In the first place, the issues being complained about borders on somebody's personal life. That's the first one. Now, when you look at Article 12 of the 1992 Constitution, it talks about the enjoyment of rights and enforcement of rights and protection of rights regardless of a person's creed, religion, gender, opinion, whatever the person you could describe. And Umar, when you read Article 17 of the 1992 Constitution, with permission, let me read. It says that Article 17:1 says that all persons shall be equal before the law. Article 17:2 says that a person shall not be discriminated against on grounds of gender, 2, race, 3, color, 4, ethnic origin, 5, religion, 6, creed, 7, or social or economic status. Any standard dictionary that describes what we call social status will tell you that a social status is either the level of social value a person is considered to possess, or, how the person is seen in society vis-a-vis other people. In other words, how the person manifests his social conduct and, what the person chooses to do with him or herself. Then, Umaru, beyond that one, when you read Article 21, it provides that all persons shall have the right to, if you look at the A, it says that freedom of speech and expression. Expression here means, what the person chooses to say, how the person says it, whether it's verbal or by video or by a picture or whatever. The Constitution says that the person has the right to freedom of expression. And when you look at Article 21(1)(b), it says that the person has the freedom of thought. In other words, how the person even think is the person's liberty, the freedom of conscience and the freedom of belief. Now, when you put these rights together, what it means is that what the General Legal Counsel is seeking to do is to invade the privacy and the social life of another person. And to all intent and purposes, if the General Legal Counsel, had contemplated this, that should have been part of the original criteria by which people are called to the bar. Then under those circumstances, we can say that for every law student, when you have gone through the law school, you've written your exams, you've passed, you've done your internships, and you have actually done your moot court, you passed all of them, you actually passed your interview. We are going to display all of you. That way, we are going to investigate everyone's social media account. We are going to publish you and ask people to either write reviews about you and your account. Then we could then have people's, former side chicks, people they broke their hearts, people who have done all kinds of things, and then a petition. And the General Legal Counsel can then take a decision whether somebody had a good moral character or not. So clearly, this application is completely discriminatory. It is unlawful, it is unconstitutional, and it's very, very arbitrary.
What is the gatekeeping mechanism or gatekeeping role of the Ghana General Legal Counsel? And do you not reckon that this is what they're doing with this?
I think that the General Legal Counsel is going beyond its mandate. Look, when you read Article 296 of the 1992 Constitution, it talks about, the exercise of discretionary powers. And for the purpose of our listeners, let me emphasized by either the law school authorities and all that. It says that, A, that discretionary power shall be deemed to imply a duty to be fair and candid. That's number one. Number two, it says that the exercise of the discretionary power shall not be arbitrary. Two, it shall not be capricious. Three, or biased either by resentment, prejudice, or personal dislike, or shall be in accordance with the due process of law. So really, please, whose morality are you talking about? Is the personal dislike of the one who is taking the decision? Have you published any clear-cut criteria that determines what amount to morality and what is immoral? I mean, so please, and in any event, you are trying to use somebody's past. It's not the case that the person is a lawyer, a practicing lawyer, and has done those things, and you want to use that as a way to impeach her credibility as a lawyer or something. You are saying that because the person once upon a time showed those either pictures or videos on social media, even though she is qualified by law, and even though she's passed the exam, she's passed all, she's fulfilled all the conditions, you can't call her to the bar because you are going to investigate her moral conduct. I mean, by what moral authority would you do that? By what law would you do that?
They say that you get called to the bar. It's not a right. It's a privilege, and that privilege can be withdrawn. You don't agree?
So, by what law do you determine the circumstances under which that privilege can be withdrawn? That is the arbitrary use of discretionary power that I'm talking about. The mere fact that I am sure that in many, as a legal counsel, if they had known that people like us may be more critical about them after we have become lawyers, I'm sure we will never have been called to the bar. You see, so the question is that, by what standard do you determine that privilege? So, yes, okay, granted, you are supposed to determine what amount to morality, whether somebody is morally good or have a good moral character and so on and so forth. By what standard do you determine that? If you cannot give us clear standard by which you determine that, then you are acting arbitrary and you are acting unconstitutionally. And unfortunately, you are discriminating against somebody who had done nothing against you except to live her own social life. And in any event, our social lives, and everybody knows that, look, agreements made in social settings are presumed to be even unenforceable. And my learned colleague knows that. And so you see, things that happen in social media and so on and so forth, social media spaces are people's private space. That is why nobody is under a duty to follow people on social media. If you follow them, then, it is your choice to follow them.
So now that they're asking students to present their social media handles.
And that is equally unconstitutional. Because it's somebody's private account. And they put on their friends and their family members, and when they go on vacation, they want to show with their family members. They are restricted friends and other things.